Tuesday, and you know what that means. It's time for Broker Talk. We are thrilled to have the first show of our year. We're going to talk a little bit about estate planning. But before we get to that, Broker Talk is a short and deep dive into everything related to real estate. And there are so many different aspects of it. Our goal is to
Ed,
leave
can you hear
you
Larry
after
at all?
He's no, not really, no.
Our goal is to leave you with the information that you need at the end of the show. Here, let me look here. Yeah, everything is fine. Turn up your things. We're all good.
I hear you fine. I don't hear Larry. I mean, I hear him a little bit.
As I said, Jim, everything is fine from the tech part. The show's good. Stay with us, okay?
Okay.
So
I turned you all the way up.
Oh, and I feel it deep in my soul. Thank you. I appreciate that. Today, we're talking about estate planning. We have Ed Martin with us from Taylor, Ganson, and Perrin. He is an attorney. And I asked him this morning when we were talking about the show, I said, if you have a little bit of money, should you get a will or should you do estate planning? And Ed explained to me that estate planning includes the will, but it includes several other documents that are absolutely essential. The power of attorney, your healthcare proxy, the living will, the durable power of attorney, the HIPAA, which is your healthcare proxy, the
what
trust.
Comes after living will?
After the living will comes the durable power of attorney, then the healthcare proxy, and a trust if you're going to create a trust. And then finally,
Larry,
the actual will.
I have you turned all the way up to maximum, and I hear you just a little bit. Ed can't hear you at all.
All right,
you
folks.
know ASL, maybe.
All right, folks. What we're going to do here right now is we're going to try and fix what.
Now you're coming in a little bit better.
We're going to try and fix.
Now you're coming in much better.
If you would come in.
Yeah.
Yeah. Hey, Jim, let me tell you one thing. If you come in at 15 minutes before and we can set the tech, that's why we ask you to come in 15 minutes before. And then instead of the diva time, right at the minute the show starts. Should we just yell at each other rather than talk about, do you have your estate plan ready? Oh. And now I don't hear him.
He's on mute.
Anyway, Ed, you can hear me now, right?
Yes, I can.
So let's talk about the various aspects of these things. Power of attorney. Why would you need a power of attorney? And who do you give it to?
Okay, so a power of attorney, basically that allows someone to stand in your shoes, handle your finances. They could sign your tax return for you. The person who has a power of attorney for you is a very important person, and it's somebody you really need to trust implicitly, because they can do a lot. They can go to your bank account and write a check for you if you need to. So as people get older, a lot of times it's better that they have that in place, because if something happens to someone and there's an account that's in their name alone, if they don't have a power of attorney, those assets are basically frozen, and then someone would have to go to court to become a guardian or a conservator in order to gain access to those funds.
So the healthcare proxy is a similar thing, but it's for the health.
So the healthcare proxy, basically you're naming someone to make healthcare decisions for you if you couldn't make them for yourself. And again, a lot of times husband and wife or spouse, and just spouses will name each other first, and then either it could be a child or a trusted friend or brother or sister. I've seen parents. So it's just somebody who you trust who's gonna make a healthcare decision for you if you can't make it.
Exactly. I'm going to skip over the will and the living will and hold them for the end because it's important and there's some distinctions. But the durable power of attorney, how is that different than the power of attorney?
Durable just means that it's valid whether you're incapacitated or not. So as soon as you sign it, basically, and the agent signs it, it's in effect. And that's what we use. We don't have documents that just say power of attorney. They're all durable power of attorneys for us.
Okay. And the healthcare proxy is kind of like the HIPAA. Am I correct in thinking that?
Well, the HIPAA document it's a separate document, and basically what that does, that has your name, your date of birth, it has some identifying information for you, and then it just lists the people that you named in your healthcare proxy. And what that document does, that tells the hospitals, the doctors, all the medical professionals that they need to share the medical information with these people who are in fact your healthcare agents, because if they're going to make the decisions for you, they should have everything that they need to look at to make the right decision.
So the trust, many people, especially people of means, will buy their home in a trust, not in their own name. I know that trust means more than just hiding your assets. It's protecting your assets as well, right?
Right. There's a lot of different types of trusts. What you're talking about is typically if someone wants to purchase their home in the name of the trust, what that does, that keeps it out of probate. So when they passed away, it doesn't have to go through the probate process because it's already in the trust, and then it can be distributed to the beneficiaries more smoothly at that point.
Which brings us to both living will and then the other will. You're either uh, intestate or not, and that means your will. Explain those terms a little bit.
Okay, let's back up to the living will first. The living will, um, basically, what that does, that basically says if you're being kept alive by artificial means, and if you have maybe some brain injury, or you've been in an accident, and you're pretty well gone, or if you have an incurable disease, that document basically you can sign something that says I want procedures withheld. That's what used to be called pulling the plug. Now, that document's not legally binding in Massachusetts right now. So people say, okay, well, why do you still prepare it? Well, the reason we prepare it is ideally when you name a healthcare agent, you should have that conversation with them. It says basically, if I'm in this one of these conditions, pull the plug, or don't keep me hooked up. So what and when you name someone, typically you should have that conversation. If you didn't have that conversation, or maybe the second person, you have it with your spouse, but you don't have it with your child or your brother. And if they're put in that situation, they're sitting there saying, geez, I don't know what Larry wanted. I don't know if I should pull the plug. I don't know if I should keep him hooked up. So what they can do is they can go back and look, back January 14th of 2021, when Larry supposedly had all his marbles, he selected that he would want the plug pulled. And so when that person makes that decision, if they were leaning towards pulling the plug, it gives them a little comfort. It takes them, it gives them an out. So they don't feel so guilty. They say, okay, this is really what he wanted, and I'm just really following his wishes. Now, so that's the living will. Now, the other document that you mentioned, it's called the last will, or last will and testament. That's the document that most people think about with estate planning. So with that document, basically you're telling the world where you want your assets to go when you pass away. And you also tell everybody who you want to be in charge of your estate and handle everything. Now, the will covers what is in your name alone when you pass away. So if you think about it, if you have a bank account with your spouse or with a friend, and it's a joint account, when you pass away, that asset automatically passes to the surviving owner. It doesn't go under your will because it's not in your name alone. Additionally, life insurance, where you have a designated beneficiary, you pass away, if you have a beneficiary, that asset automatically goes to that beneficiary. It doesn't go under what your will says. Your will can say, I'm leaving everything to Larry. And if I have a life insurance policy and I make it payable to Jim, sorry, Larry, you're not getting it. It's all going to Jim. So the
Jim,
will,
you're really savvy with your money and all of this. Do you have all of this set up? Because I don't. That's why I'm talking to Ed. Oop, we don't hear you.
on mute.
Okay.
You were
I
muted.
cannot confirm or deny.
I didn't. Ed, in fact, is I belong to a BNI, Business Networking International, and Ed is one of the members of that BNI. And he, at one of the meetings, explained, "What is your tagline?" I love this tagline.
Plan now or pay later.
Exactly, exactly. I think that resonates with a lot of people. And my concern was, well, how much does this cost? Because it's not, it's not a six pack of beer, it's not a steak. So I need to protect my money. And
Legal Zoom.
yeah, legal Zoom.
Yeah,
Uh,
go ahead to LegalZoom. I like people that go to LegalZoom because they end up back with us anyway because they don't have anybody to explain things to them. Something happens, you pick up the phone and you call me, and I explain the documents. I explain how they work.
LegalZoom is the for sale by owner of estate planning. You know, it's the do it yourself. I don't need no stinking lawyer. And so you really always need a professional, somebody who's been there, somebody who has done it over and over again, just like in real estate. I mean, you can go and buy and sell real estate without a real estate person, but you're not going to negotiate in the same way. You're not going to understand where you have leverage, where you don't have leverage. You get into the final negotiations, you're not going to know what they're thinking based on experience. You're going to be guessing at that point. Um, it makes sense to work with a professional. And that doesn't mean go
So,
to,
so, so how many documents are we talking here? One, two, three, four, five, six.
So the
Right?
basic ones he went over. It's healthcare. It's power of attorney, durable power of attorney, healthcare proxy, living will, HIPAA document, and the will. Six.
the
That's
one you
five.
left out was the trust.
The trust and the trust. Not everybody needs a trust. I've had clients that come in and they say, "Oh, I need a trust. I need a trust." And I send out a checklist when we get started or to get started. The client fills it out, sends it back, and then if they based on the checklist, I give them a recommendation of the type of plan that they should have. Um, I had one. They said they wanted a trust. They really wanted a trust, and I'm like, well, you don't really need a trust. And they're like, well, my neighbor has a trust, and I'm much more successful than he is, so I should have a trust too. And I said, well, your neighbor probably paid $2 or $3 grand for a trust, and I don't know if they need it or not, but I know you don't need it. So if you want to pay all that, that's fine. I'm happy to do it for you, but if you don't need it, why should you pay for it?
Sure, sure. Um, these are all protections, not just for you, but for your family and ongoing. That's why it's called estate.
Right. So when I mentioned before about the different plans or different levels, there's basically I break it into three different levels for estate planning. I say small, medium, and large. The small plan is just the basic documents that I mentioned to you. Power of attorney, healthcare proxy, living will, HIPAA document, and the will. And for a young couple, husband and wife, everything going to each other, that's pretty simple. That's basically all they really need. Now, if they have children, one of the biggest things that prompts people to actually get their estate plans done is when they have children, because if something happens to the parents, who's going to be the guardian? Who's going to take care of my kids? That's the biggest thing that prompts young couples. Um, and in your will, you can name someone who's going to take care of your children if something happened to you, and that's a very powerful thing. Now, if people have young children and they have some assets, quite a few assets, they may want to have a trust. And the reason, so those assets can be held for the benefit of the children until they reach certain ages. So, if you didn't have a trust, basically, if you have a will and you both parents passed away, the children would inherit at age 18. Now, I
So
don't know
what are
how
the
much.
tax implications there?
Okay, so with that type of trust, there's no tax benefits to it. And let me just finish how that trust works. And the reason, I don't know how many 18-year-olds but I don't really think they should be given hundreds of thousands of dollars or millions of dollars at age 18. So what happens is we set up a trust, like it's called a joint trust, husband and wife, everything's to each other, and then when they both pass, it's held for the kids' benefit until they reach certain ages, like say 25, 30, 35, when they get incremental amounts of the principal. So that's the medium plan. Now, you were asking about the tax provisions. So the next level up, the highest level, would be revocable trust for both husband and wife. And in that situation, what you're doing is you're putting in estate tax savings provisions. So each state, not each state, most states have an estate tax. In Massachusetts, it's $1 million. So if you die and your estate is over $1 million, you have to file an estate tax return. Now, what these trusts do, they choose its exemption. Basically, you're able to shelter up to $1 million of assets that won't be included in your spouse's estate when they die. So basically, you're saving on estate taxes by using that larger plan.
So that sort of doubles the amount that you're not paying taxes on?
So basically, what happens is when the first one passes, you want to shelter up to $1 million in assets. That's not going to be included in the surviving spouse's estate. If you didn't have that type of trust, and one person dies, you're just stacking all the assets on top of the second spouse's estate when they die. So what you're doing when you set up the two trusts, you're setting aside basically $1 million worth of assets. This is just for Massachusetts. That's not going to be included in the survivor's estate.
I want to get further into like what happens when you divorce and you have other children right after our commercial break. So let's take that away. We'll be back in a moment.
When you are searching for a new home, you want to be working with a realtor with years of experience, a professional with intimate knowledge of the communities that you are considering moving to, and someone who really wants to represent you as a buyer in what is probably the largest investment you will ever make in your lifetime. The realtors at Castles Unlimited want to be your choice when you are ready to make your next move. Please visit us at castlesunlimited.com or call us anytime at 800-967-3.
And we're back. I wanted to ask you. So you figured this out with your wife and your children. You have a divorce. Now, what do you have to change? Because I would think that you would want many of your assets. Either partner would rather them, instead of the ex getting all of the assets, they would probably want to keep them to their children or somewhere else. How do you deal with those kinds of things?
So when you may have a second marriage too, which throws in some more issues. But basically, when the divorce is final, you should change your retirement account, the beneficiary of that. You should change your life insurance beneficiaries. Anything that you have in joint name with your initial spouse, they should all be changed. Because if not, what happens? You pass, it all goes to that person who's a joint owner. And you'll change absolutely, you would change your will as well, because what you had maybe going to your spouse, now you just want it to go to your children.
Right. And in real estate, you have, tenants, in common and tenants by the entirety. Those are different terms, and they signify different ownership levels.
Right. So
How do you?
tenants by the I think we lost Jim.
Yeah.
Tenants by the entirety. Basically, it means the property is owned jointly, and the people are married. Um, another, so there's, I look at it as three different levels. There's tenants by the entirety, then there's joint tenants, which is just, two people who own property jointly. So if one of them dies, that property automatically goes to the surviving joint owner. And then the third level is what's called tenants in common. Now, if you divorced and for some reason you kept the real estate, you and your spouse ended up keeping the real estate, basically you would want that property to be owned by what's called tenants in common, because then you can direct where your one half interest would go upon your death. It would go under whatever your will says. If you kept it at joint tenants, you don't have that option. You pass away, that property automatically goes to the surviving joint owner.
This is one of the ways you. Go ahead, Jim.
I was just going to ask a quick question. In the case of someone getting their estate planning done and they've got corporations that they own 100% of these corporations, how do you usually counsel the business owner?
If you have a business like that, basically I would ask you first, do you have what's called a buy-sell agreement with the business? Number one, if you have it with somebody else. But if you own it all yourself, there needs to be provisions in your will that basically say the personal representative can take over and can manage that for a short period of time. I think it's like 2 years if it's like an S corp. So those provisions. C corps, you'd be transferring the ownership through your will or through a trust. So you just have to have provisions in there telling you where those assets would be going.
And who would be taking over the charge of the business?
Right. That would be more. I mean, in a succession planning, basically, you should have that in place. And if not, I'd work with you to basically get that in place to begin with, because it's just the corporation is just one additional asset that you have. I mean, people have real estate, they have life insurance, they have retirement accounts, they have bank accounts, they have brokerage accounts, and if you own a business, you got your business too. So it's you got to take care of it. You got to provide for where it should go and who should be taking it over.
Many of the
Larry, do you want a little piece of the wiener business?
Sure, love to. Jim owns a company called the Savage Wiener. They are awesome steak gourmet hot dogs, really tasty, and that's another sponsor. We didn't run that ad; we ran the Castles ad today.
We're getting pretty close to being sold out. It's crazy.
There's a day that there'll be no hot dogs.
Yeah,
that would be a sad day. But
I've got a puppy here. Podcasts love puppies. Hold on.
Yeah, just don't fall off the chair. He's doing it again.
I heard he fell off the chair last.
How cute this dog is. What types of what's your name of your puppy?
Layla's name is what's your name, Layla? I forget.
Anyway, hey, how do some of our audience is not going to be in Boston area, and they may have to talk to other estate planners. What are the types of really good questions to ask an estate planner? How are you differentiated?
Basically, when I meet with a client or talk to a client, the first thing I do is I send out a checklist to them. And so I get their email address, I send the checklist, and then when they send it back, that's when we start working. The checklist basically gives me a snapshot of what their assets are. And then also at the end, it has some blanks to fill in. Basically, who do you want to be your power of attorney? Who's the successor if that person's not available? Who's the personal representative? Now, the personal representative is who takes care of everything under your will. It used to be called an executor, but now it's called personal representative in Massachusetts. That one, basically, that's basically someone who cleans up whatever mess you leave behind. no matter how neat you are and how organized you are, there's still going to be a little mess when you pass away. There's also provisions there for the guardian. Who do you want to be the guardian of your minor children? Um, the healthcare agent. Who do you want to appoint as the healthcare agent? So the five basic documents that I mentioned initially, those are the things you worry about. Estate taxes. That's when you should get into talking about trusts. Or if you have minor children and you want to make sure that the 18-year-old doesn't get uh, hundreds of thousands of dollars or millions of dollars when you have a trust in place as well. You want to
Exactly.
ask you also want to ask them what they're going to charge. I typically give clients a range for the services, and I don't start the documents until we agree on a price.
Yeah, which makes perfect sense. Um, but I did ask the question I really asked at is um, uh, when I came to you, I had specific questions, and you immediately had say, "Let me have your email address, and let me send you this form," which would give you a snapshot, you, the estate planner, a snapshot. But having someone responsible to set all this up, you want to really feel comfortable with liking and trusting, and many people just don't know the right question to ask.
I see. So basically, what I would ask them is estate planning their primary practice? I mean, I do estate planning and estate administration. I don't do real estate. I don't do divorces. I don't do litigation. Really, you need someone who does this all the time because they're going to understand. They're going to know different things that you may run into. The experience is a big thing. And if you could go with someone who has less experience, as if they have someone that they work with or can bounce things off of, that's fine because you can't start on your own with 10 years of experience. You got to learn some things, but it would be good if you went to someone who's working at a firm, you say, if they're just starting, they're trying to build their practice, if there's somebody else that they're working with, that's fine too. You have somebody looking over the documents to make sure everything's okay.
Well, I
So
certainly,
let's say somebody has, I'm sorry, let me just jump in. Well, let's say someone has zero as far as the work that needs to be done. And they do have a business. They start with the business first and then work towards the personal.
Yeah, get the business straightened, but just think. What I tell clients is just think about it. If you pass away today, what happens? What happens to all your stuff? Does it go where you want it to go, or doesn't it? And if it doesn't go where you want it to go, you need an estate plan to get it there. And if you do it now, it'll be less costly than if you do it if it has to be done after you've passed. There's something called the Intestate Statute that says where all your stuff is going to go. So you can either do your stuff now and try to get it to where you want it to go, and the people to your loved ones, or it may not. It'll go based on the intestate statute. The intestate statute basically says your assets will go to your closest blood relative when you pass away if you haven't put anything in writing.
Okay. And
so your closest blood relative or your wife?
Married, if you're married and you have children, it goes one way. If you're married and have no children, it just goes to the spouse. Even if you have if all the children are children of you and that spouse, it goes to the spouse. Um, and you can see in situations where you may be married but you have children from another marriage, or so the intestate statute breaks it down into how everything goes.
so how does it go? How does it go in that situation?
Well, if you go, they get a percentage. Like the spouse will get a certain portion, the kids will get a certain portion.
So if it's one kid, one spouse.
Well, if it's one kid and one spouse, if it's the same, if the let's say it's the husband and wife and they have one child.
No, not the child.
No, a first wife.
Exactly.
A first wife had the
Right.
child, and divorce, and then so you've been married longer time to a second wife.
Do they split it?
Well, The intestate statute will split it, but if you do your will, you don't have to
Right.
worry about that.
Right.
That's all.
Right. What about the TV show Succession? Have you seen that?
I have.
I have seen it. I don't know. Is it coming back on? I haven't seen. I haven't seen.
I would like it to.
I'm sure it'll come on. So is that pretty accurate? What goes on in those cases where, I mean, this is
Where there's a lot of money involved. It's amazing what goes on, because the more money that's out, the more,
Yeah, exactly.
You know, I do see when, if both parents are alive, kids pretty much, they play nice. When the parents pass, sometimes if they're not that close, what happens is they say, "Hey, I was just being nice because mom and dad were here. Now I'm really pissed off at you, and you know what? We're going to fight over all this stuff." And that's really unfortunate. I say it goes one or two ways when parents pass. Either the kids all get closer together, which is great, and sometimes they just diverge and fight, and everybody resents everybody else. And
Well, I think I've seen that in many families where you have one of the children is successful and the other child is not. And they might be still living at home. They might be getting support from the family. Then it gets a little bit messier. But those are two.
there's a couple of well-known fights even in Massachusetts in families.
Sure.
It gets into the news.
Demolises,
That's one, and legal seafood.
the legal seafood people
But
as well. They have attorneys and they're working that through all of that stuff. But Ed, thank you so much for giving us so much information. Ed works at Taylor, Ganson, and Perrin. Plan now or pay later. I like saying that. Ed, thank you for being a guest on Broker Talk today.
Thank you, Ed. Very informative.
We're on our way out. Thanks, everybody. Oh, it's time.